Hello, everyone, and thank you so much for joining the Colorado Department of Labor and Employment today. I'm Tracy Marshall, Division Director of CDLE's Division of Family and Medical Leave Insurance, and I'd like to welcome you to our 9th installment of our Family Monthly webinar series. Today, I'm also joined by our Family Policy Unit Manager, Evan Grimes. Evan and I will be guiding today's discussion on coordination of benefits and providing an update to the newly adopted family rules and regulations. Before we get started, here's some quick housekeeping for you. So a copy of this presentation deck and the recording is available on family.colorado.gov. There you can also find recordings of our previous webinars. They cover a variety of topics, including family and local governments, calculating your family premiums, benefits and employer participation, and we also have a two-part series on private plans. We do have a lot of information to cover today, so we will go ahead and get started. So here's a quick pulse check on our implementation timeline. We are currently in the process of rolling out our online employer services portal, in which employers will register with the division, and then they'll use that to pay premiums and to submit quarterly wage reports. We've completed our soft launch by allowing small groups of employers to register in the My Family Plus employer portal in phases. Around 1,000 organizations have successfully registered during this phased approach. The system will be available to all employers very soon from family.colorado.gov. Starting then on January 1st, 2023, you'll need to have your payroll system set up to start deducting premiums from your employees and then sending those payments along with wage data in the My Family Plus employer system. Every employer will need to register within the My Family Plus employer system in the first quarter of next year, before the first premium is due on April 30th. We will be offering a 30-day grace period for the first payment before we consider it to be late. We do want to make sure we give you plenty of time to get comfortable using the system. And then finally, beginning on January 1st of 2024, family benefits will become available to covered workers. I'm going to hand over to Evan now to talk about our coordination of benefits rules.
Great. Thank you, Tracy. So today, as Tracy mentioned, we'll be focusing on our recently adopted rules regarding the coordination of benefits. So first, let's start with how family will work with employer-provided paid time off, or PTO. Workers cannot be forced to use their accrued paid time off before or during their family leave. However, an employee may choose to use their PTO before taking family leave. Employers and employees can mutually agree to use any accrued PTO to top off the paid family benefit, so the employee receives a full wage replacement while on leave. However, such an agreement must be in writing. If PTO is used to supplement family leave, the total amount of paid from both sources may not exceed the employee's average weekly wage. If it does, or if the employee receives payments from PTO and there wasn't a written mutual agreement between the employer and the employee for that top-off, employers can consider those portions of the employer-provided paid leave to be an overpayment that they may recoup through a lawful deduction or through other legal means. If that happens, the employer will need to replenish the appropriate bank of leave accordingly. Now, one of the frequent questions we hear is, what benefits are employers obligated to continue when an employee is on family leave? While an employee is on leave, employers are required to maintain their healthcare benefits, and employees are still required to pay their premium obligations toward those healthcare benefits during their leave. Now, healthcare benefits include any health insurance, dental insurance, vision insurance, and any mental health, counseling, and addiction services that are provided by the employer. Employers have a few options with regard to how to collect those healthcare benefit premiums from their employees during family leave. They can deduct from PTO paid to the employee that's meant to top off their family benefits. They can deduct from wages when the employee returns to work, so long as the deductions are in accordance with the Colorado Wage Act. They can enter into a repayment plan with the employee, or they can collect the amount through other legal means. Employees are not entitled to continue accruing employer-provided leave or any other benefits while they are out on family leave. Another common question we get is how the family benefit interacts with workers' compensation. Family benefits may not be taken with workers' compensation benefits for the same reason for the absence. If someone is absent from work because of a work-related injury or illness, they cannot simultaneously claim family benefits for that same condition. However, if they are still working after the injury or illness and need to take leave for an unrelated issue, family benefits may be used. Any condition compensable under the workers' compensation umbrella is not eligible for family benefits. Applicants and healthcare providers must disclose this information on the workers' family application. And if they do not, then benefits paid to them may be considered an overpayment, and they may be disqualified from receiving family benefits. Now to unemployment benefits. Workers cannot collect benefits from both the family division and the unemployment insurance division at the same time. If an absence is caused by a situation that would provide unemployment benefits for workers, workers cannot also collect family benefits for the same absence. Workers must disclose to the family division any unemployment payments received while they are out on family leave. Next, regarding the interaction of family benefits with short-term and long-term disability policies, if the reason for family leave also qualifies for short-term or long-term disability benefits offered by the employer may count both the wage replacement amount and the duration of the family leave towards the limits included in the short-term or long-term disability policies, so long as it first gives written notice to employees. Now moving on to how family works with the federal FMLA. While Colorado's family program is designed to run concurrently with the FMLA, the family division does not manage or adjudicate FMLA claims. When a worker applies for FMLA, the employer must also tell them that they may be eligible for paid leave under the family program. But ultimately, for questions related to FMLA, please visit the U.S. Department of Labor's website linked here. Now, in addition to our newly adopted coordination of benefits rules, we also recently adopted a few amendments to our previously adopted rules for premiums and local governments. So in our premium rule amendments, we clarified that employers will be responsible for determining their total employee headcount as it relates to determining premium liability during the initial registration process and once a year thereafter during the first quarter of each year. We'll have more details on how to count your employees on our employer page of our website, family.colorado.gov. Also, the definition of wages was clarified. The family definition of included and excluded wages now mirrors the unemployment definition of included and excluded wages. We have a summary of these wages on the employer page of our website. Employers who are exempt from paying unemployment premiums are not necessarily exempt from paying family premiums, and these employers should refer to the list on our website to determine what counts as wages. And then in our local government rules, we revised the definition of local government to clarify that any employer that is either covered by House Bill 22-1133, which involved the state of Colorado's prepayment of premiums, or has at least one employee covered by the state personnel system is not a local government. And then before we wrap up, I want to quickly recap our adopted rules for private plans. In order to qualify for an approved private plan, employers must offer a plan to all employees that provides all the same rights, protections, and benefits as Colorado's Family Paid Leave program. Thus, in order to be approved, a private plan must offer at least the same number of weeks of benefits, offer at least the same level of wage replacement for each week of benefits, include no additional requirements or conditions, deduct no more from employees' wages as the employer would be authorized to deduct under the state plan, cover all Colorado employees through the duration of their employment, and of course, remain compliant with any additional requirements established by the family division. We understand employers need time to shop around and consider their private plan options, and that private plan market hasn't been able to develop until we adopted our private plan rules. Therefore, all Colorado employers will begin paying premiums in 2023, and those who secure an approved private plan effective on or before January 1st, 2024, will be able to apply for a refund of paid 2023 premiums minus a private plan administration fee. The private plan administration fee is $500, and employers with approved private plans will also have to pay an annual maintenance fee thereafter based on costs rising out of the administration of that employer's private plan. We anticipate opening up the private plan marketplace sometime between the first and third quarter of next year, at which time we will provide more guidance on how to apply for private plan approval within My Family Plus employer. The deadline to submit an application so that a private plan can be effective by January 1st, 2024, and therefore make the employer eligible for a refund of 2023 premium payments is October 31st, 2023. But the biggest takeaway here is that all private employers will pay premiums next year, and those who choose to go with a family division approved private plan effective by January 1st, 2024 will be eligible for a refund of 2023 premium. And now I will hand it back to you, Tracy.
Thanks, Evan. Let's move on to some of the frequently asked questions that we've received through our email box from employers. If we're a local government that opted out, we have employees that voluntarily want to opt into the FAMLI program. When they're out on leave, do we have to maintain their healthcare benefits?
No. Family laws and regulations do not require opted out local governments to maintain those employees' benefits during leave, but the terms of an agreement or some other law or regulation might.
How about nonprofits? It states that employers must also maintain healthcare benefits during leave, but the employee would have to continue to pay their share of the cost. Does this mean employees are responsible for paying the employer portion during that period of time?
So employers, including nonprofit employers, are required to maintain an employee's healthcare benefits during leave. Employees are still obligated to pay their own employee portion of those healthcare benefits, but not the portion that is typically covered by the employer.
How about religious organizations? So they're exempt from unemployment premiums. Does that mean that they're also exempt from FAMLI?
No. Employers who are exempt from unemployment premiums are not necessarily exempt from paying family premiums. These employers should refer to the list of wages subject to family premiums that's posted on our employer page on our website.
Thanks, Evan. So we do want to hear from you. You're certainly welcome to share your feedback with us on private plans and any other family matters. You can engage with us in a variety of ways. Our email address is listed here on your screen. You can also be alerted to ongoing updates by following us on Facebook, Twitter, Instagram, and LinkedIn. You can also subscribe to our newsletter and update your preferences by going to family.colorado.gov. We welcome you to participate in any upcoming public hearings regarding our current and forthcoming proposed rules. That wraps up today's webinar. Thank you so much for your time and for your participation.